of diseases like breast cancer. Since 2018, our work with these technologies has been guided by our responsible AI principles, which are supported by a robust governance structure and review process. My colleague Tulsee has been at the center of this work.
Canada has an exceptional opportunity to build on its investments in fundamental research in artificial intelligence, and this committee can contribute to the development of a legislative framework that establishes strong public safeguards and leverages economic and societal benefits.
Government's efforts to establish the right guardrails around AI. And we also share some of the concerns that others have raised with this committee. We believe the bill can be thoughtfully amended in ways that support the government's objectives without hindering AI's development and use. There is no one-size-fits-all approach to regulating AI. AI is a multi-purpose technology that takes many forms and spans a wide range of risk profiles. A regulatory framework for these technologies should recognize the vast range of beneficial uses and weigh the opportunity costs of not developing or deploying AI systems. It should also tailor obligations to the magnitude and likelihood of harm specific to particular use cases. We believe that ADA should establish a risk-based and proportionate approach, tailored to specific applications and focused on ensuring global interoperability via widely accepted compliance tools such as international standards. And we hope to continue to work with the Canadian government, as we have with governments around the world, to build thoughtful, smart regulations that protect Canadians and captures this once-in-a-generation opportunity to strengthen our economy, position Canadian innovators for success on the global stage, and drive transformational scientific breakthroughs. Thank you again for the invitation to appear. We look forward to answering your questions and continuing this important conversation.
Merci beaucoup.
Thank you very much. And now I would like to give the floor to Rachel Curran of Meta.
My name is Rachel Curran, and I'm the head of public policy for Meta in Canada. It's a pleasure to address the committee this afternoon. So Meta supports risk-based, technology-neutral approaches to the regulation of artificial intelligence, and we believe it's important for governments to work together to set common standards and governance models for AI. It's this approach that will enable the economic and social opportunities of an open science approach to AI and also bolster Canadian competitiveness. So Meta's been at the forefront of development of artificial intelligence for more than a decade. We can talk about that later during this hearing. But this innovation has allowed us to connect billions of people and generate real value for small businesses. For our community, AI is what helps people discover and engage with the content they care about. And for the millions of businesses, particularly small businesses who use our platforms, our AI-powered tools make an advertiser's job easier, which is a real game changer for small and medium-sized businesses who are looking to reach customers who are interested in their products. In addition, Meta's fundamental AI research team has taken an open approach to AI research, pioneering breakthroughs across a range of industries and sectors. In 2017, we launched our AI research lab in Montreal to contribute to the Canadian AI ecosystem. Today, Meta's global research efforts are led by Dr. Joelle Pineau, who's a world-leading Canadian researcher and a professor at McGill University. And she is the one who heads up Meta's global AI research efforts. So our Canadian team of researchers have worked on some of the biggest breakthroughs in AI, from developing more diverse and inclusive AI models to improving healthcare accessibility and patient care that's benefited communities in Canada and abroad. This work is shared openly with the greater research community, a commitment to open science, and a level of transparency that helps Meta set the highest standards of quality and responsibility, and also ultimately build better AI solutions. Look, we applaud Canada's leadership on the development of smart regulation and guardrails for AI development. particularly through its leadership on the Global Partnership for AI and the G7 process. We strongly support the work of this committee, of course, and the initial aim of Bill C-27, which is to ensure that AI is developed and deployed responsibly, while also ensuring that the global regulatory frameworks are aligned, maintaining Canada's status as a world leader in AI innovation and research. We do think that AI is advancing so quickly that measures focused on specific technologies could soon become irrelevant and hinder innovation. And as we look to the future, we hope that the government will consider a truly risk-based and outcome-focused approach that is going to be future-proof. So in that regard, we'd flag a few specific concerns with C-27. First, one proposed amendment from the minister to this bill would classify content moderation or prioritization systems as high impact. We respectfully disagree that these systems are inherently high risk, as defined in the legislation, and we would suggest that the regulation of risks associated with content that Canadians see online would be better dealt with in pending online harms legislation. Similarly, the proposed regime for general purpose AI, we think is not appropriately tailored to risk and more closely resembles the requirements for truly high impact systems. We suggest that the obligations for general purpose AI should be harmonized with international frameworks, such as the ongoing G7 Hiroshima process, which I referenced earlier, the White House voluntary commitments, and OECD work on AI governance. Lastly, we'd flag the audit and access powers contemplated by Bill C-27. We think they are at odds with existing frameworks, for example, with the approach by other signatories of the Bletchley Park Declaration arising out of the recent UK AI Safety Summit. So that includes the US and the UK. And again, we'd encourage Canada to pursue an approach that preserves privacy and is consistent with global standards. So members, we believe that Meta is uniquely poised to solve some of AI's biggest problems, weaving our learnings from our world-leading research into products that billions of people and businesses can benefit from, while continuing to contribute to Canada's vibrant, world-leading AI ecosystem. We look forward to working with this committee and to answering your questions. Thank you.
Merci beaucoup.
Thank you very much. Ms. Craig from Microsoft, the floor is yours.
Thank you, Mr. Chair and committee members, for this opportunity to... Sorry, your microphone. Sorry. I will start again. Thank you, Mr. Chair and committee members, for the opportunity to testify. At Microsoft, we believe the immense opportunity AI presents to contribute to Canada's growth and to deliver prosperity to Canadians. To truly realize AI's potential and to improve people's lives, we must effectively address the very real challenges and risks of using AI without appropriate safeguards. That's why we have championed the need for regulation that navigates the complexity of AI to strengthen safety and to safeguard privacy and civil liberties. Canada has been a leader in putting forward a framework for AI, and there are positive aspects of the legislative framework that provide a helpful foundation going forward. However, as it currently stands, Bill C-27 applies the rules and requirements too broadly. It regulates both low and high-risk AI systems in a similar way, without adjusting requirements according to risk. And it includes criminal penalties as part of the enforcement regime. Not all risk is created equal. Intuitively, we know that, but it can be difficult to determine risk levels and adjust for them. In our view, the set of rules and requirements in ADA should apply to AI systems and uses where the level of risk is high. For example, ADA applies the same rules and regulatory obligations to a high-risk system, like AI used to determine whether to approve a mortgage, and to a low-risk system, such as AI used to optimize package delivery routes. Applying the rules and requirements too broadly has several implications. Businesses in Canada, including small and medium-sized businesses, will need to focus on resource-intensive assessments and third-party audits, even for low-risk general-purpose systems, rather than focusing on where the risk is highest or developing new safety systems. A restaurant chain and its AI system for inventory management and food waste reduction will be subject to the same requirements as facial recognition technology. This will spread thinly the time, money, talent, and resources of Canadian businesses, and potentially mean finite resources are not sufficiently focused on the highest risk. Canada's approach is also out of step with that of some of its largest trading partners, including the US, the EU, the UK, Japan, and others. In fact, the Canadian law firm Osler has published a comparison of ADA with the EU's AI Act, which I'll be happy to submit to the committee. The comparison includes 11 examples where Canada has gone further than the EU, creating a set of unique requirements for businesses operating in Canada. Going further than the EU does not mean that Canadians will be better protected from the risks of AI. It means that businesses in Canada that are already using lower risk AI systems could face a more onerous regime than anywhere in the world. Instead, Canadians will be better protected with more targeted regulation. By ensuring that ADA is risk-based and provides clarity and certainty on compliance, Canada can set a new standard for AI regulation. And we firmly believe that with the right amendments, it is possible to strike the right balance in ADA. You can achieve the crucial objective of reducing harm and protecting Canadians, and you can enable businesses in Canada to be more confident in adopting AI, which will provide enormous benefits for productivity, innovation, and competitiveness. In conclusion, we would recommend, first, better scoping what is truly high-impact AI. Second, distinguishing the levels of risk of AI systems and defining requirements according to that level of risk. And third and finally, rethinking enforcement, including the use of criminal penalties, which is unlike any other jurisdiction in the OECD. This would also ensure Canada's approach is interoperable with what other global leaders like the EU, the UK, and the US are doing. We are happy to provide this committee with a written submission detailing our recommendations. Thank you, Mr. Chair, and we look forward to your questions.
Thank you very much. And so to start the conversation, I'll yield the floor to MP Perkins for 6 minutes.
Thank you, Mr. Chair, and thank you, witnesses. So I'm going to start at a fairly high level because we have the world leaders in AI before us today. It's a pretty special committee meeting amongst a whole series of special meetings we've had on this bill. But when you have Amazon, Google, Meta, Facebook, Microsoft, all before us, you guys are the world leaders and putting the most money in everywhere. This bill was tabled almost 2 years ago. Just a yes or no. Were any of your companies consulted on this bill before the bill was tabled? So one at a time, if you could.
So no, we were not consulted before the bill was tabled.
No, we were not consulted.
No, not before the bill was tabled.
Online?
To my knowledge, we were not consulted.
Okay. So I find that shocking, frankly, that you wouldn't have been consulted. You've had meetings, I assume, since the bill was tabled, because the minister claims 300 meetings, but most of them were with academics and think tanks. In those meetings, have you proposed any specific amendments to the bill? If I could go through one at a time, same order.
So further to my remarks, we did advocate that there was need for greater clarity for developers and deployers in terms of defining their responsibilities in the Act.
But actual amendments?
That specific amendment, I feel like, was a reflection of our comments. I think the other specific comments that we don't think were were heard was really sort of the need to really differentiate between high and low impact more clearly, and better clarity around the criminal provisions.
Yeah, we also raised the concerns that I raised in my opening statement, which is content moderation and prioritization systems. So essentially the content that Canadians are seeing online should not be scoped in as high risk. So we raised that with department officials, absolutely. We raised our concerns around remote access. We also raised concerns around specific obligations for general purpose AI systems. So the issues I raised in my opening statement, we have raised.
Yes, we've also had the opportunity to provide input since it was tabled and shared proposed amendments and fixes, also similar to what I raised in my opening remarks with regard to the need for a focus on high risk, for rethinking enforcement, and thinking about the requirements being differentiated based on risk.
And online?
So we've shared our concerns with the proposed text, and we will be pleased to share specific amendments with all committee members.
So that was going to be my next question. If you proposed actual wording amendments, could you please share them with the committee?
Of course.
A number of you mentioned interoperability. How is it possible to be interoperable with other countries when other countries haven't got legislation on this? Mr. Curran.
Yeah, can I answer this? Because this is a really good question. So, look, I understand Canada wants to act quickly to regulate AI. The original form of the bill, which was a very high-level framework and would have allowed a lot of these issues to be discussed and finalized during the regulation-making process, I think would have allowed Canada to align with other international jurisdictions. The problem is the amendments the minister has proposed to the bill in his letters to the committee take a position on all of these issues which are currently under discussion in international forums. So as part of the G7 process, as part of the Bletchley Declaration, as part of the OECD process, other jurisdictions or peer jurisdictions are discussing these issues now. And so what the minister's proposed amendments, if accepted by this committee, are going to box Canada into a regulatory framework that may look very different from the one that emerges from international discussions. So that really is our concern, not the original text of the bill, but the amendments proposed by the minister.
Right, so if I could go to that, originally the bill only dealt with high impact systems without a definition.
Right.
My problem with this bill is everything originally was in regulation, including the definitions, including the policing, except for the penalties, of course. They knew how to penalize something they couldn't define in the bill.
Right.
So that's been replaced with two more definitions, general impact and machine learning. And in high impact, you referenced, they actually have done a definition and a schedule that they can amend by regulation after the bill passes. And number 4, I think, is the one that talks to the moderation of content. Is this a backdoor way to do C-11?
Yeah, and I'm not sure if that's deliberate or not, but really we think this is better sort of dealt with in the context of the pending online harms legislation. So this will really determine
hold on here.
What Canadians...
I have to pause that. Is this a backdoor? I didn't see this coming. A backdoor with C-11. If you remember, this is like a lot of people, I believe that the government was going farther than they should, and basically helping the larger players on the internet. Okay, freedom of the internet. I'm just replaying it.
For the penalties, of course. They knew how to penalize something they couldn't define in the bill.
Right.
So that's been replaced with two more definitions, general impact and machine learning. And in high impact, you referenced, they actually have done a definition and a schedule that they can amend by regulation after the bill passes. And number 4, I think, is the one that talks to the moderation of content. Is this a backdoor way to do C-11?
Yeah, and I'm not sure if that's deliberate or not, but really we think this is better sort of dealt with in the context of the pending online harms legislation. So this will really determine what Canadians see online. So whether it's something that appears in your social media feed or your YouTube recommendations, or even as something as innocuous as a Canadian company deciding how to rank, camping gear for purchase by Canadians using an automated system. Dealing with the regulatory obligations that are proposed in this bill are really going to impact the way those systems work. So we think this is better dealt with in a context where we can have a free and kind of robust discussion about where the line should be drawn in terms of content that Canadians see. I know department officials have said that this provision is designed to deal with misinformation, for instance. So let's have a discussion about where that should be drawn in the context of a bill that's designed to deal with that.
Ms. Craig, you mentioned low risk. Low risk, in other words, is now being classified, I presume, a lot of it into the general purpose. So I use this example of previous writing. I've got a seafood company in my writing that's using AI to determine whether something's a surf clam or a scallop and what direction it should be in before it goes into the machine to be shucked. That would if it got used by other companies and got sold, fall under general purpose. Is that the kind of thing, it seems like it's excessive. Is there any AI that wouldn't fit into a general purpose definition?
I think that we should apply the same approach to high risk versus low risk, even when we're talking about general purpose systems. So that same technology that you're talking about can be in a high risk context or a low risk context. So even using visual search, for example, is using computer vision technology or facial recognition technology. And so even there can be very low risk contexts for general purpose systems or high risk. I think we need to apply the same kind of lens around high or low risk. And to go back to your question about making our legislation more interoperable internationally, the best shortcut we have to that is to really lean on the work being done by international standards organizations and bodies to kind of determine what the right standards are for how these systems are deployed and designed. By referencing those instead of creating bespoke Canadian regulations, it really provides a huge enablement to Canadian companies that want to be able to scale globally, whether they're using AI or not.
So are we too early?
You can create the framework for those things now and then reference those pieces as they evolve. We're going to see a number of international standards probably be published in the next few months, so that work is happening at a very rapid pace. But again, the technology is also evolving at a very rapid pace. So I think you want to kind of give yourself flexible frameworks and allow that international technical work to inform what Canada will have to rely on as well.
And thank you. Yeah, just going back to your original question, I think that is the exact point that I was trying to make in referencing low-risk systems. In the legislation referred to as general-purpose systems, but that are quite broadly defined to contemplate technology that's just used for multiple different purposes or multiple different activities, which could encompass quite a broad swath of technology. And as Nicole said, technology that is used in low-risk or high-risk circumstances ending up being treated similarly by being impacted by requirements, even if it's just really used in a low-risk context.
Thank you very much. We'll now turn to MP Sorbara for 6 minutes.
Thank you, Chair, and welcome, everyone. It's not lost upon me that as you folks are giving your presentations, that literally millions, if not hundreds of millions of people are using your clients or customers are using your services right now as we do this panel and are benefiting from those services and for productivity purposes, being connected, and obviously the AI is driving a lot of that. So there are a lot of positives going on with AIs, with artificial intelligence that people benefit from every day without even thinking twice about it. And it's something that obviously we are looking at, and we've looked at for 2 years now, and which requires, in my view, would be guardrails, if I can use that term, or guardrails or safeguards. And I've heard a few terms that have been brought forth in terms of content moderation or ecosystem, high impact versus low impact. My first question, because I'm going to try to keep this high level. In terms of the differentiation between high impact and low impact systems, where is the right balance in terms of that? And I take us back to like sort of an accounting approach where you have principles and you have very prescriptive. How do we strike that balance between high impact and low impact when we're viewing AI and we're not spending a ton of bureaucracy or a ton of time capturing the low impact systems, which in themselves are quite beneficial for consumers and for companies? I'll just start with Nicole, and we can just go across and then to online, please.
I mean, I think we would sort of start with anything that could impact a meaningful decision that may impact an individual's human rights or health and safety. So I think we would sort of probably start with that as the kind of basic definition, and then it is an area that I think considerable debate went on the EU to really kind of clearly define what those exact use cases are. But there are even low risk systems that you wouldn't even regulate all high risk systems the same way. The questions you would ask would be different, and the risk assessments you would do would be different.
Because Nicole, just before we go to Rachel, I did write down in your comments, you said high impact currently is too ambiguous.
Yes. It's very, so for example, there are lots of use cases lots of times, for example, healthcare will be viewed as a high impact use case, or human resources and recruiting, for example. Well, if you use a video conferencing platform to conduct job interviews, you're using AI, and that I would argue that is not a high risk use case. You know, the system is identifying a face, it may be blurring a background, it may have
not to cut you off, because I do want to hear from the others. Yeah. Rachel, Amanda, then John, please.
Yeah, I would agree with that. I think it's the definition of harm. So if you set a threshold of material harm in various areas, you're going to almost certainly capture high impact use cases. So for instance, we've dealt with delivery of healthcare services, absolutely. But Nicole referenced human rights issues. So ads that target accommodation, employment, or credit opportunities raise human rights issues and should probably be defined as high impact. So it's really, I don't think you have to capture every possible use case, but if you at least set a legal threshold of material harm, you're going to capture most high impact cases.
Oh, no. So I think it's a really hard but important question. At Microsoft, we've been contemplating this as well, and establishing our own internal governance program and understanding how we calibrate application of our requirements in that governance process to higher risk scenarios. We have developed 3 categories of what we call sensitive uses internally at Microsoft. The first is any system that has an impact on life opportunity or life consequences. So in that category, we think about systems that impact, for example, opportunities for employment or education or legal status. The second category is any system that has an impact on physical or psychological safety. So think about safety critical systems in the context of critical infrastructure, for example, or systems that might be used by vulnerable populations. And then the third category is any system that has an impact on human rights. I do think it's useful to have a framework to think about what is a trigger for higher risk, and then where there is readiness to go further, to think about some of the more specific sort of use cases like education, employment, and that is represented in some of the high impact examples in ADA as well. And then also to recognize, though, that there is going to be a need to evolve and to put guardrails in place for how you think about the high impact systems and the examples evolving over time, not just having an open-ended process, but thinking about what's going to be a trigger for meeting that bar going forward.
Thank you. I'd like to go to Google, and I know there were some documents that you were going to send to committee. A few people mentioned if you can send them to, that'd be great. Any background information is worth. Can we get Google to comment real quick? And thank you, Chair, for the time.
Yeah, thank you. I think I would echo a lot of the comments from my counterparts there, and point in particular to the definition of harm, because I think that could solve a lot of issues here. If you have a test of material harm, then that can resolve exactly what the threshold is for both the identification and mitigation of risks associated with specific use cases for AI systems. And right now, the definition simply says harm, including psychological harm or economic harm, but there's no calibration for what harm is really defined as, or the test for that.
Merci. Monsieur Garon, la parole.
Thank you so much, Mr. Garon. Thank you very much, Chair. And thanks to all the witnesses for being here today. As a citizen, as a consumer, I love your products. I use your products, especially as someone who loses his way when driving a car. So we've heard ad nauseum about all of the benefits these services products provide, and we love them. Now, I want to come back to Mr. Sorbara's question, which I found very interesting. We talked about high impact and low impact systems, high risk, low risk, and technologies that are evolving very quickly. And I understand that some technology can have many uses, which makes it all quite complex. And I understand your message, which is there are some definitions that are very narrow about high impact, low impact, and in some regards you don't agree with that, which is legitimate. Which gives rise to my question. Could it not be normal that the definition that the legislature provides, because it wants to protect the public, have a different definition than what high impact, low impact, high risk, or low risk is? That is the definition of industry. That our roles are different. So could our definitions not be different?
So I think it's perfectly legitimate for legislators to have a different view of high versus low impact AI, and I think the point of the discussion is really to try to kind of make sure that the finite resources that Canadian companies have are not sort of used unnecessarily to do kind of really complex assessments where maybe it's not necessary. So just to give a little bit more context around that, some risk assessments are actually in the millions of dollars to complete. They're very complex, and they require a lot of due diligence and information. And then once you've completed that risk assessment, you likely want it audited by a third party in very high-risk use systems. That is not a small undertaking, especially for small companies that may be, startups and looking to start up their new businesses.
If you'll allow me, we sometimes interrupt you because we have very limited time. Now, we have been told that it could be useful to have a federal registry of some of the large generative models, and businesses would have the obligation to submit models, codes, with the risk assessment depend on usage. You find that too complex?
Complex. It's that it actually isn't necessarily going to be an effective way to evaluate whether a system operates appropriately for that use case. So what we do for customers is actually provide good information and complex, good kind of clear information about recommended use cases for the models that we offer to customers. But the only way to really kind of evaluate how that model performs appropriately for your use case is to test it. And so you in that testing process with your data, you're going to be able to kind of test and evaluate if it's performing appropriately for your use case. Just kind of throwing up a bunch of models is not really going to actually be that effective in giving us that information.
Madame Curran?
Madame Curran, I would like to hear you expand on something you said, if you'll allow me. We talked about C-31 and moderation of content, and a colleague asked you, would the moderation of contents not mean deciding what Canadian and Quebecers are going to see on the web. I mean, content we see on, Google Form is very deterministic. It's very focused on what people looked at previously, and it gives rise to lots of concerns. I would like a clear answer. Your company, it also chooses what people see on the internet.
It does. So we pick up signals from what people are interested in largely. We've applied a lot more sort of transparency and control around that for our users. So you can click on, a piece of content and go to why am I seeing this? And you can find out what signals our systems are reading in order to show you that particular piece of content. So we're trying to give users a lot more control over that. So you're right. Our systems do decide what's most relevant and most interesting to our users. Our fear with this is that with an onerous kind of regulatory system applied to that kind of content prioritization, that ultimately it's going to be up to government regulators what we should be showing to Canadians.
But you mentioned that you were in favor of a kind of American approach, and that this was something that might be desirable. So you think that the voluntary approach, self-regulation, might be a success? I mean, do you think that citizens can trust what the industry will self-regulate in the event of crisis?
No, I don't think self-regulation is the right approach. I'm someone who's worked in government for a lot of years. I'm actually a fan of smart regulation. The issue is, what kind of regulation is applied and how those issues are debated. So the government has indicated that it's in the process of preparing an online harms bill, and we think that's the context in which to debate where that line should be drawn. So we have always said to governments, you tell us what you define as disinformation or misinformation, and we'll make sure we enforce against those rules. Like, that would be a lot easier for us than engaging in an internal debate, which we do daily, around where the line should be drawn and what content we should allow on our platforms. So we are very happy to engage in those discussions, and we would love policymakers and decision makers to set those rules for us. But there needs to be an open debate and a robust public debate around where the line should be drawn. And in this case, I think another member referenced the fact that this looks like content regulation through the back door, and it doesn't really allow for that kind of open and informed and public debate around where to draw the line in terms of acceptable content online.
And I know I'm probably going to cut my time on our next turn, but the approach you believe in, that is to use, a legislation which would do essentially the same job, would that not be to regulate what people are seeing on the internet through the back door? Is that not contradictory in terms of an approach?
I don't think so. I mean, we would like government to, if it's willing to regulate content issues. Those are sensitive issues. They're constitutionally sensitive issues. There are kind of federal, provincial aspects to that kind of discussion. And so, if government wants to regulate in those areas, let's have that discussion and let's have it openly. I think if we're asked to regulate content through a provision in an AI regulation bill, that's not going to allow us to explain why we're showing particular content to Canadians, or why we're restricting particular content for Canadians on the grounds that it's misinformation or disinformation. That's not fair to our users. It's not fair to Canadians that they won't understand why we're taking those decisions.
Merci. Merci beaucoup, Monsieur Massé.
Thank you very much, Mr. Massé.
And thank you to the witnesses. Just as a public awareness and to my colleagues, I will be tabling a motion, not for debate for today, but for a subsequent meeting, and looking for feedback and also if there's amendments, that the Standing Committee on Industry and Technology send a letter to all auto manufacturers who sell vehicles in Canada requesting a written brief describing the measures that they are taking to improve security features and address auto theft in Canada, and that the response be submitted to the committee within 5 working days. We've done this before in this committee, and the reason I'm suggesting that we do that is I don't want to turn this entirely over to public safety or to transport because of the amount of money that's going through this file to the auto industry, and it won't take committee time, but we'll actually be able to figure out whether or not we might want to have a more comprehensive study about that issue in the future. So looking forward if any of our colleagues have amendments to that, and that'll be in your mailboxes tomorrow morning. Now, thank you to the witnesses, and I guess the first thing that I want to ask, it relates to, the fact that we have an issue here. We either trust the bill through regulation and a little bit of vagueness, or we trust the industry by not having any legislation, and that could mean upwards of 5 years, quite potentially, depending upon Parliament and how long it lasts. And even if it didn't last, to get something through would take a lot of time. And so we have kind of a decision to make. And I guess the first thing I'd ask, Ms. Curran, you mentioned that you were in public policy before. I think you worked for Prime Minister Harper, if my memory is correct, as Director of Policy. And the question that I have for you is that in July of 2019, the U.S. Federal Trade Commission imposed a record of $5 billion fine against Facebook for deceiving users and their ability to control the privacy of their personal data. And why would we continue? And I guess the first thing is that in that case, and I don't know, were Canadians actually under the same, problems that Americans were? And then the second part is why would we just trust that no public policy would be the best policy at the moment versus the bill?
Thank you for that question, Mr. Massey. So I don't think we are arguing that there should be no legislative framework, and our position may differ from my colleagues here a little bit on that. I actually think the bill in its original form, as it's written now, minus some of the amendments that have been proposed by the minister, is actually quite good and quite workable. I understand the political imperatives here. I understand the concern that the public has for generative AI products in particular. I think it is incumbent upon the government and decision makers to put some kind of guardrails, as Mr. Sabara talked about, around the development and deployment of AI. Our only caution is that Canada not do that in a way that's so far out of alignment with other jurisdictions that it's really going to have a negative impact on the development and deployment of AI in this country.
Sure. And on that issue, though, I mentioned about the Federal Trade Commission, how much was actually allocated to Canada for reparations on that? There was a reciprocal amount that came to Canada to what because you're asking for some harmonization here with other countries. So on that particular case, there was $5 billion. Was there any reparations to Canadians that were affected by the breach that the U.S. Federal Trade Commission did? Because we actually sometimes get money from even consumer abuse in the United States through a number of different processes. So did any money come to Canada for that breach of trust?
I don't know the answer to that, Mr. Massey, but we will follow up to get you that information.
I appreciate that. And I want to move now to Ms. Foster, because you mentioned about criminal provisions. And this is part of the challenge that we're faced with here. So in July of 2020, Amazon was hit with a record of almost $900 million U.S. From the European Union fine for processing personal data in violation to the GDPR rules of privacy violation. In that particular case, were Canadians under the same privacy violation that the GDPR citizens got reparations for in that particular case? Did Canada get any reciprocal treatment for the privacy violations that may have taken place?
I'm not aware of the particulars of that case. I'm also here on behalf of Amazon Web Services as opposed to Amazon, so it's more difficult for me to answer.
Okay, so would the Amazon case with the U.S. Federal Trade Commission be something that you're familiar with? That's with regards to the delivery drivers in a 2.5-year period where their settlement was there. Was that one
My
that you'd be familiar with?
expertise is around AI for Amazon Web Services as opposed to Amazon, so I don't have the expertise.
Okay, well, no, I appreciate it. I'm not trying to put you in an awkward spot here, but you mentioned about the criminal provisions, and I have other lists of fines and penalties against Amazon in the United States and the Federal Trade Commission for that, and that's part of what we have to decide here is some of those elements, and Canada really, quite frankly, isn't getting the same treatment in terms of citizens, and the facts are. Maybe I'll move to Microsoft then. So Microsoft has agreed to pay $3 million in fines for selling software to sanctioned entities and individuals in Cuba, Iran, Syria, and Russia from 2012 to 2019. The U.S. Department of Treasury says that the majority of these apparent violations involved blocked Russian entities. So to Microsoft, is some of that activity still taking place, or is that now completed? And, how can we trust entirely if there's no regulations related to AI and stuff like that and the waiting period to do something if we hear of cases like that?
I unfortunately also don't have the expertise to respond to your question about the specific case. I will say, I think from our perspective, there is an opportunity to still move forward with this regulation, with this legislation, and to do so in a way that's swift and that addresses real concerns that exist about AI and deployment in high-risk scenarios, with making adjustments to the amendments around approaching high-impact systems and defining requirements for the general purpose or lower risk systems. Okay, so if you don't,
sorry, I have limited time, and
sure.
If you don't know that one, then I'll move on to this one because it is about really what we're talking about here. Is the U.S. Federal Trade Commission had charges that Microsoft violated children's online privacy protection, and this actually does involve privacy protection for ourselves in terms of what is age of consent. And I was just wondering whether in that case there was a $20 million settlement for that, whether under Microsoft were Canadians also under the children under the same violation that took place in the settlement. And these, some of these cases that I have here, this isn't hard research. This is from the New York Times. So I'm not asking anything that's of, unknown preparation or gotcha stuff. It's just the New York Times information that you just use your products to find out. And so I wanted to know, did Canadian children have the same exposure that has been settled in the United States?
And we'd be really happy to follow up with you. I unfortunately just don't have that information today. Okay.
Mr. Chair, I just have one quick yes or no question with regards to the 3% digital services tax to all the companies. Are you opposed to the digital service tax that's been proposed by Canada? And if yes or no about that, I'd be interested to know the positions. And I can go by company or individuals or whatever, or I'll leave it in your hands, Mr. Chair, but I'd be interested to know, yes, support the digital service tax for Canada or oppose it. That would be interesting to know.
I think the digital services, the concerns with the digital services tax are more the timing in terms of Canada's moving forward out of step with other jurisdictions. Less concerns about the tax specifically. It's more the timing and alignment with other countries.
Fair enough.
Exactly our position as well. As long as there's a globally harmonized approach, we're happy to pay more tax, happy to pay a digital services tax. Just don't make it a one-off.
And we also support an internationally harmonized approach such as that's being advanced through the OECD.
We also support the OECD process and international corporate tax reform.
Yeah, thank you for that. And the reason I asked that is because I'm vice chair of the Canada-U.S. Parliamentary Association, where when we go to Washington and we have congressional senators.
Okay, this is, I just have to pause. I know there's only a few of us here, but it was funny. We're looking at, they're all capitalists, and there's nothing wrong with their positions at all. They're all working for companies, but it's painful when they're like, they have to. They're basically, have to say, yeah, we're okay with tax because they usually in everyone's charter is we abide by the laws within the countries we operate, right? So that's in there. So it's an automatic statement that comes out. But it's still, at the back of, any capitalist person anyone who works for a business, yes, I want my company to tax me harder. I want my company taxed harder. Is not words that roll off the tongue. And the NDP, of course, this is their bread and butter issues, right? With companies. Anyway, just a slight interesting point. Artificial intelligence, Mr. Roboto.
As well, that have been actively lobbied by your companies to get them to tell us to oppose the tax. And you can just do a quick search and you find that many of the individuals are actually receiving financial donations. And with that, I think I'm out of time, Mr. Chair.
You're way out of time, Mr. Massey, but I feel generous tonight, and I've been with all members, so that's how I do it. But Mr. Williams, the floor is yours for more or less 5 minutes.
More or less, hopefully 7. Don't take away my time, Mr. Chair.
Don't forget us in the third round.
Thank you, witnesses. I want to focus tonight looking at international standards, catching up to some of our peers when it comes to minimizing harms to artists, creators, and the general public. So I know you all agree you have consumer products that you want to protect creators and consumers. A biggest concern of AI is people control how their likeness could be used for profit, where the likeness is valuable, reflects an investment by the individual against online harms. Obviously, we also want to protect consumer use and rights. The examples we have today, some of the biggest ones are, I had a group I met with yesterday from Music Canada. There's an AI-generated Johnny Cash who can sing Barbie Girl by Aqua perfectly. So this is computer system learning an artist, replicating it. We look to maybe what could happen if that was used with Michael Jackson or others to create full albums. Who's protecting it? Are the laws there to protect consumers and, of course, consumer rights? The second one is deepfakes. So deepfakes are very concerning. The biggest example right now is Taylor Swift. And that's also been something that is not just for celebrities, but also it's been something that a colleague of ours, Michelle Rumpel-Gardner, has been especially vocal on the use of AI-generated fake photos and videos for intimate partner violence. So looking at those concerns, that material harm, how do each of you see Canada catching up with ADA or with existing legislation ensure we protect consumer rights? And I'll start with Ms. Foster and we'll go around the room.
Sure. I also have a household full of Swifties, so we talk about this at the dinner table. I think actually you've raised a great example where existing legislation could be more purpose-built to solve a problem like that. So it is already illegal to share intimate images without consent. I think adding the sort of clarification in the criminal code to ensure that it covers AI-generated images is likely probably a more effective vehicle to address that particular issue. And so I think that could be something that Canada could act on very quickly and very efficiently. The industry is also working pretty hard to ensure that it is much easier to detect AI-generated content. So as part of the commitments that we made in July at the White House was a commitment to develop watermarking and other tools to detect generated content. By November, we'd already released a watermarking tool within our Titan AI model. So the industry is trying to also move very quickly to address some of these harms and make sure that not only are obviously collaborating to make sure that there are laws in place to address them, but what can we do on the technical side to help it, ensure that those images are detected quickly. The copyright question, I think, is a very hot topic, and the government has a consultation on this. From a policy perspective, I think there's two sides to consider. Both, I think there's the AI training and the data input, and how do we allow for greater kind of assurance that we have great data to train models. But there are also and there are techniques to on the output side to ensure that we suppress copyrighted content. So it is possible to ensure that models do not that they have suppression techniques to ensure that copyrighted content is not on the output side of the model. So I think there's two sides. I think it's good to sort of separate the discussion into understanding the two aspects of AI, but also ensure that we have good AI. We have good models that also reflect Canadian content as well. We have a bit of I think we should also think about the fact that most models that are available are either dominated by Chinese language or English. There's a lack of, for example, French language content, but we have other minority languages in this country as well. And so we want to make sure that we permit appropriate content use for training models to ensure that we have access to Canadian-specific large language models when we interact with them.
Yeah, I'd agree with that. So the issue you've raised around deepfakes, both video and audio, would not be addressed by C-27, at least not anytime soon. Now, I know the government's made an announcement, I think today, around the issue of deepfakes and an intent to deal with those. Those could be dealt with very easily through an amendment to the criminal code or existing legislation. Same thing around election disinformation. If that's a harm that committee members are concerned about, that can be addressed through a quick amendment to the Elections Act. So there are existing statutes, and even the Copyright Act on issues of creator rights. Use of material in the context of AI development that impacts creator rights can be dealt with through the Copyright Act as well. So there are existing statutes. We have advocated previously for a sectoral approach because of this to AI regulation. But those could all be dealt with very quickly. They won't be dealt with in the context of C-27 quickly.
And with regard to deepfakes, I think similar to my colleague from AWS, we see an opportunity to either make adjustments to the criminal code or think about opportunities to address that concern in the upcoming online harms legislation.
All right. I looked at some research. Researchers, there's actually a Canadian company who's at the head of this. One company, but the U.S. military is really there. And what they're saying is it's going to take AI to decipher AI. And because we in the West, America, and Canada, we have a couple of pretty big companies. We're pretty good in AI department. Not good enough though, in my opinion. The university should focus harder, I think. The AI will be basically searching everything and be able to do the certifications through that technology, because the speed thereof checking it in the way that it already works, it's already perfectly placed for detection of AI. So that's like they said, that's going to be like the first use of government-run AI systems or government-funded or whatever for public health, right? That's what I'm going to say. After this election, I believe that this election, no matter what, I think we're going to get bombarded with it, and I kind of hope we are, and then we'll sort it out most likely after this election. We know the advertisement that are probably coming out most likely is going to be bogus, so it'll be fun. Let's listen to the experts.
With regard to copyright, I think from our perspective, there's a need to think about how we're enabling use of AI to advance the spread of knowledge, to enable new creative works consistent with copyright law, and to protect the rights and needs of creators. And that's something that we want to continue to engage with partners, with governments on how to achieve those objectives. And that's why we think it's been really productive to have the ongoing consultation that we submitted a response to, and look forward to any further opportunities to follow up on that.
Similar to others, we see other vehicles as being an appropriate mechanism to address the incredibly legitimate concerns around images of that sort. And I want to be clear that non-consensual intimate images we have a zero tolerance policy to that on Google, regardless of whether those images are synthetic or not. and we provide tools to individuals who might find themselves in that terrible situation so that they can address it, or so we can support them in addressing it, rather. We also have very clear policies with regards to our own generative AI tools that ensure that, generating sexually explicit content of this sort is a prohibited use. I think maybe my colleague Tulsee can also speak a little bit to this issue about, because detection and watermarking are really important technological advances where we're going to need to have a very collaborative approach.
Yeah, unfortunately, we have a technical issue. We can't hear you, but perhaps we'll have time to get back to you at some later point. And in any event, Mr. Williams, you're out of time, so I'm sorry. We'll cut it off here, but hopefully we'll have the chance to get back. Mr. Gahir, the floor is yours.
Great. Thank you, Chair. Thank you to the witnesses for making time for this committee as well. My questions are largely for Microsoft. So, Ms. Craig, how do you believe the government should approach regulating a field that's evolving so rapidly? And how do you think ADA sort of gets that right in meeting that challenge? One of the examples that I think of is, the initial schedule for high-impact systems that can be edited as technology evolves as time goes on.
It is incredibly important in terms of just an overall approach to legislation and regulation of technology and AI in particular, to think about establishing a framework and a process through which you can iterate over time with appropriate guardrails in place. So, for example, allowing the high-impact kind of system schedule to continue to kind of reflect growing deployment of this technology and new high-risk scenarios by adding to it over time, with appropriate guardrails in place, though, so ensuring that the process by which that happens also requires that the additions reflect that kind of same risk analysis and a threshold that is being met to add to the schedule. I think also ensuring that the processes for implementing requirements, for example, are evolving over time with kind of changing approaches to safety systems for AI is important. And ensuring that the risk-based approach is really foundational to the regulation will be important. Ensuring that the way that the regulation applies is not overly broad and having the onerous requirements apply to low-impact systems that restricts how Canadian businesses can continue to use AI for lots of innovative purposes.
On that bit, regarding compliance, ADA with the proposed amendments that are currently there, are they sufficiently specific for Microsoft to plan its compliance efforts? And would you already be in line with some of those efforts, given your existing internal structures?
The legislation and the recently proposed amendments provide a high-level sort of structure for requirements. Mm-hmm. And through the implementation process, we expect that there will be more detail for defining the requirements. There's also the enforcement approach in which there is an ability, for example, through the power to audit that is less specific, that there seems to be an opportunity to provide more detail through the implementation process about how organizations can demonstrate compliance with the requirements that will be defined in more detail. From a Microsoft perspective, we have been working on internal governance for responsible AI for 7 years, and we have developed a lot of these constructs internally that we can think of as a starting point. We can imagine a lot of other organizations may have not been spending as much time or have as many resources to apply to that issue, and so providing more certainty on how to comply will be of incredible value. For us, we have developed our responsible AI principles, and we've developed a responsible AI standard to put those principles into practice, which really looks like a set of really specific goals and requirements that apply to internal teams working on AI to fulfill practices like ensuring that we are reducing bias, mitigating the risk of bias, ensuring that we have sufficient transparency and accountability built into our processes.
I'd like to ask the same question to the panel generally, like compliance with ADA. How is that for your respective companies?
Yeah, maybe I can chime in on here. I think Amanda's being very diplomatic. So ADA in a number of respects goes well beyond kind of the most stringent proposal out there internationally, which is the EU AI Act, which already is the subject of a lot of debate amongst member states. Doesn't have the support of countries like France, for instance, who want to ensure their own domestic industry is given a chance to flourish. So ADA has created a standard that doesn't exist anywhere else in the world. So look, if you're asking us if that standard were imposed here, would we meet it? Sure, like we have the resources to meet it. The compliance costs are incredibly high. Would that mean that certain products may not be launched in Canada? Maybe. But all of us work for companies that are able to meet very high thresholds because we have the resources and the money to do that. It's going to have a significant negative impact on the Canadian AI industry and on innovation in Canada. So I guess that's kind of the word of caution. When I say Canada should align, it's to make sure it's aligning itself with other jurisdictions. We're a relatively small market. The EU is setting a benchmark that is kind of, world leading. We should at the very least not exceed that.
I echo the comments of the panel, but I would say that I hope the committee is going to have the opportunity to hear from Canadian companies that deploy AI, where AI is not maybe their core business, but they are companies that deploy it in their business. And understanding the impact that these kind of regimes are going to have on the agriculture industry, the financial services industry, manufacturing industry, energy industry. So this technology is being deployed not just by AI developing companies, but our customers are in every sector of the economy in Canada. And so I think the committee should really take some time to hear from Canadian companies that are going to be impacted, who leverage our services or may develop their own services. But that which should be, I think, a high priority for this committee to hear from them.
And virtually?
Yeah. From a Google perspective, obviously, we've been public in our commitments to have responsible AI principles, and my colleague Tulsee is at the center of our governance process around that, which is scalable and an incredibly rigorous and robust process. I think, similar to some of the comments we've heard from others, one of the areas where you might want to consider focus is in the definition of high impact to insert some considerations about the threshold of what would need some factors that would define a high impact system. And that might give you provide both the clarity as well as flexibility for as the technology evolves. So if you think about, severity and probability of harm, scale of use, nature of the harm, these types of things, by giving some guidance to regulators, will help to both provide the certainty and the protections that the government is looking to establish here, while also, giving clarity and predictability to companies large and small who will need to build the systems to comply with this. And I think we have a real opportunity right now to get this right from the outset, and that's to build a coherent and consistent policy environment for Canadian companies who are going to need to be prepared to take on, to succeed on the global stage.
Great, thank you.
Merci beaucoup, Monsieur Garon.
Thank you very much, Mr. Garon. Thank you, Chair. Will ask you the question, Ms. Curran. I could have asked it of someone else, but the industry, and I repeat, it's an industry we like, and its sense of responsibility, of course, we want to enhance that further. But there are things that are not being done. They should have maybe been done. We've talked about identifying deep fakes, so forth, and people wonder how come that's not been done yet. Of course, you work in a competitive environment. You have competitors. So I wonder, in the current environment, is there not a cost in terms of markets and profits to raise ethical standards above that of the competition?
To be clear, we don't allow deepfakes.
I like this witness, Rachel Curran. She's like Machiavellian to the ninth degree. She's like Miss Machiavellia incarnate, and you can kind of see. They're kind of wearing. I was thinking about it. They're wearing corporate uniforms, so we were laughing about it, but that's like a force multiplier in the room. So, if they're wearing some other type of outfit, who knows what they're? You're going to go look at their little badge or something that notes that they're with each other. You saw them. But the way that they've got here, they're a team, and they're a team. She's not going to say nothing. That's the team. So it's like maybe they'll be doing some lobbying later, and they'll know, someone will know, you can talk to that person if she's discussing something in the corner with someone else. It's force multiplier. This is, corporate uniforms. I'm a big advocate for them. A lot of the problem is you can't push corporate uniforms on many corporate people. They're like, what do you mean? I have my own suits. Whatever. But anyway, I just wanted to note some Machiavellian use of Meta.
Video, audio on our platform, and we have developed a number of tools to take those down and identify them.
No, but can we stick to the question? I just have 2 minutes. My question is there a cost in terms of markets, profits, customers to when you raise those standards above those of your competition? That's the essence of my question.
No, I don't think so. I mean, look, to the extent that we want to be a trusted, credible brand, and so we want to be world-leading, industry-leading in terms of ethical standards. So I think there is no negative cost to that. I think there is a positive benefit to that. But what we're talking about here is the standard that Canada is setting in terms of regulation of AI systems, and there will be a cost if that regulation, that threshold, is set at a level that far outstrips our international peers.
Merci.
Thank you. And a last question. Ms. Craig, we talked about high impact being risk to health, human rights, and security. If I've understood, that's essentially the criteria. Now, electoral interference or disinformation on a daily basis. Mr. Chair, could you give me 20 seconds back? So, as I was saying, is the interpreter coming through, Ms. Craig? I'll try. Can you hear the interpretation, Ms. Craig?
Here, take my sweaty one.
So what was defined here as high impact systems were, risks to health, human rights, and public safety, which is a good definition. I'm not an expert, and I'm sure all of that's extremely important. Now, disinformation. Electoral interference.
I think Google's motto is...
Where does that fit? Is it under
Google.
health, human rights?
That's all it needs to be.
Is that definition going to evolve?
You were referring to the sensitive uses. I guess I should keep this definition afterwards. Sure. So I think there are ways to think about, disinformation risk that would certainly fit into the categories that I described in terms of potential kind of psychological harm or impact to human rights. I think what's really important is that there's an approach to defining high risk that is clear and that can evolve for these kinds of changing challenges like misinformation and disinformation. And that's the opportunity in ADA to define clearly what's high risk and a process for evolving it over time.
Merci.
I think so. I think your question kind of points out the challenge of trying to have such broad, sweeping, horizontal legislation, because it's very, very difficult to try to capture all of these very specific use cases in one piece of legislation. And in a lot of cases, it actually might make more sense for example, to direct Health Canada to look specifically at how to navigate complex use cases that are occurring in the healthcare industry, or directing the financial services regulator to be dealing more with those use cases. Those are extremely complex use cases for people like us, for example. So while we might be really kind of smart at understanding AI policy and risk mitigation, those are such complex use cases that those regulators already understand extremely well, and they understand how to manage risk in those sectors very well. And so it's sort of the complexity of trying to kind of create this broad legislation. It might be more appropriate to direct Health Canada to actually see what levers they already have to regulate AI in specific use cases, or OSFI to look at the financial services sector.
Or if I can, sorry to jump in here, or amend the legislation to identify specific use cases that you are concerned about. If it's election disinformation, or if it's delivery of healthcare services or accommodation services, you can insert those into this bill as specific cases that you want addressed. So you set a threshold for harm that is a materiality test. But then you can list specific examples of use cases that you are particularly concerned about, that you want addressed.
Merci, Madame Patell en ligne.
Thank you very much, Ms. Patell. The floor is yours.
Thank you. I just wanted to pick up on what Nicole Foster was saying there, because it's consistent with the approach that the United Kingdom is taking. And it really leans into the existing expertise that our sectoral regulators have in this space, because they can best understand the risks that exist for their sectors, the actors in those sectors. And they know, to the point, the questions to ask. And so I think that's maybe a cue that Canada can take in terms of how other countries are approaching this specific question.
Merci, Monsieur Massé.
Thank you. Now, Mr. Massé, the floor is yours.
Thank you, Mr. Chair. And I'm trying to, this is the quandary we're in. We either have to trust this legislation process, or we have to trust what we're hearing. And this is where we're getting mixed messages from lots of witnesses. And I noticed on our notes here, so my question is to Mr. DeVries, you're the Director of Privacy Legal for Google. So perhaps you can answer this. And I know there's been several different fines and penalties you've paid, most recently with the antitrust lawsuit in the U.S. for $700 million. But specifically, which you should hopefully know about, is the lawsuit that you had where you secretly tracked the internet use of millions of people who thought they were browsing privately, and you were fined $5 billion for it. Were Canadians caught up in that too? And are we going to get compensated for that as well, if that is the case?
Yeah, thank you for the question. I'm not aware of that settlement being outside of the United States where it was made, but our changes to the incognito mode that we offer in Chrome browser, I'm actually using it right now, they were made globally. So all of users are benefiting from those changes, which just didn't change the functionality of the system, but made more clear exactly how you were using it and what you were using.
Okay, and that's really helpful. I appreciate that. So, but the bottom line is the product then had the same consequences, whatever international boundary, but the U.S. and their citizens get compensation for the situation because a legal case went through there. Is that a good summary of kind of how that takes place?
Yeah, I would say that was not based on privacy law, the same kind of law that the CPPA would consider it in this bill. That was based on private litigation. So there's a different private litigation approach in the U.S., as you know, from Canada.
Yeah, and that's kind of where I'm at, is struggling, is how, and I do appreciate the fact that, you're open to, say, for taxes. I mean, I personally get lobbied, and so does the rest of parliamentarians and Senate when we go there against Canada's position for the digital tax. And the reason I'm raising that is that the position of all of your companies, despite all these fines and penalties that have been paid internationally, mostly in the United States and other places, Canada has the same products, don't get the same benefit or reparations. And then on top of that, we have to wait for even taxes to come in from the OECD decision, which could take another decade. So, I know I'm out of time, Mr. Chair, but and this is the disappointment that I have in terms of the challenge, I think Canadians that are lobbying us in terms of whether we act or don't act on this legislation is a matter of trust. Trust the administration and regulations or trust the companies, and then keep a blind spot for Canadian consumers because our laws right now don't even give us the same compensation that Americans and Europeans enjoy. Thank you.
Merci, Monsieur Massé. Monsieur Viss.
Thank you very much, Mr. Massé. Mr. Viss.
Thank you to all of the witnesses for an excellent discussion today. I'm going to move very quickly because I have a lot to cover in a very short period of time. Just briefly to Ms. Foster, Section 40 of the bill is in relationship to Sections 38 and 39, and it's in the case where a company or an individual would have committed a crime in contravention of the Act, and it would apply a penalty of up to 5% of the person's gross global revenues in its financial year. Are you aware of any other legislation related to artificial intelligence that applies such a fine?
I'm not aware of any jurisdiction that has such stringent fines or penalties.
Okay, just a point. Can any of the other companies present comment on the fine contained in Section 40 of the bill?
No, similarly, we're not aware. We're equally concerned about the remote access provisions in the bill, which would allow the AI commissioner to access data from all of our companies remotely without any concern for privacy or protection of that data.
Okay. Very quickly, yes or no?
No, especially the criminal provisions. We're not aware of other OECD partners taking that approach.
Okay, and Google?
No, we're not aware of anyone else taking that approach, and I would point out that the test is also a likelihood to contravene, so goes beyond what we tend to see.
Okay, thank you. On the data commissioner in Section 33 of the legislation, I'm particularly concerned about this, largely because in other panels we've heard, and it's well known that the Government of Canada doesn't have the intellectual capacity to regulate AI. So what I'm concerned about is in this legislation, we're going to be giving very broad powers to regulators, and in some cases, the minister may divulge those powers to, in the current form of the bill, a data commissioner, an artificial intelligence and data commissioner that reports directly to the minister. I'm concerned about this relationship because it may create a conflict between multiple objectives contained in the Department of Industry, namely one of economic development and then two of protecting citizens from online harms in this case. Would any of the panelists be able to comment on whether they believe an artificial intelligence and data commissioner in the context of artificial intelligence may be better served if that individual or future government organization report directly to Parliament and not the Minister of Industry?
I don't know that we have a super strong view about that, other than to say that, again, just to repeat my previous comments, I think it is very, very difficult for one organization or one person to kind of be able to understand risk mitigation in financial services or healthcare. And these are very complex use cases. I would strongly recommend that the government consider devolving the responsibilities of overseeing AI in those sectors to those regulators specifically.
Okay, thank you. I'll have one other. Does anyone else want to comment on that?
Yeah, I think that's a great idea to have an AI commissioner report to Parliament rather than to the Minister of the Department directly. As we've said, the remote access provisions in here allow the commissioner to conduct audits and access user data in companies' possession. And that's a legal power that's unprecedented in liberal democracies and even non-liberal countries.
Okay. Thank you so much. The next question I will direct to Google. You know, when I said Google earlier, my Pixel 3 said, "Hey, Brad, how's it going?" But in the first iteration of this legislation, it's on privacy, and we've had a big discussion about sensitive information, and I think what's equally important in this section of the bill as well. What we haven't talked a lot about in respect to AI up until today indirectly, and that is the impact it's going to have on children. I heard one other witness earlier mention that we need to look, and I think everyone's actually commented on this, that we need to look at take a proportionate approach for high and low risk systems. In the context of children, how would Google define sensitive information as it relates to its policies and technologies applied to children?
Well, thank you for the opportunity to respond to that. The first, safety is our number one priority, and we take a comprehensive approach to child safety. And that begins with designing age-appropriate products, then providing settings and tools for parents and users to make the right choices for them, and finally having policies that we enforce against. With regards to the specifics around the sensitivity of data from children, maybe my colleague Will can speak to how we approach privacy for children.
Well, I work, not really work at all. Of course, no affiliation, and they probably want me off, but the YouTube is one of the places I get income. And they really are on, at first I was like, oh, what's this and that? Onto, child protection on the videos, and it checks your videos. Like it does an AI check, and I think if that sees something, then it goes to a person. I'm not exactly sure how it goes, but it goes to a secondary. And it's actually, I think they've done a pretty darn good job, at least on YouTube. I can't say for everything on the internet, but of separating youth content and also not just separating the content from adult. It's also working on the creator so they're aware of what this is, because there's like all kinds. If you get anything, there's all kinds of an education on it, you know what I mean? So I think they've done a pretty good job. And also there's been no media I've read about it either. That's why I also think that. But anyway, let's hear what they have to say. What you have to say. Oh, Tracy says, what? Alberta is supporting parents and children at this point. Yeah, Rocky Mountain Lady says what is scarier than AI is how many think it won't change a thing. Yeah, not on this panel. There's only 33 of us, but a lot of people. I think a lot of people just seem busy too, Miss Rocky Mountain Lady. And then when it comes, it's just in the back of the mind. Except those who work in it. Canadian government does not, says Tracy. Okay, let's listen to them. Thanks for watching, listening.
Yeah, and thank you. And with respect to data related to AI or any data, we're going to take the circumstances of children into account. And obviously not as a monolith. You're going to think of children who are younger and for whom their parents will be very closely involved in their use of our products or services, and you're going to think about teenagers who have more agency but still are a special audience.
I think that's the key. I think that's the key point right there, and I'm sorry for interrupting. But in the United Kingdom, they designed privacy legislation that was proportionate to age. Do we need to do something similar for artificial intelligence regulation as well, and maybe perhaps be a little more explicit as it relates to high impact systems, with designating certain ages and the impact it could have on the psychological development of children? Mr. DeVries.
Yeah, I'm happy to talk about that with respect to data use in general, and my colleague Jeanette could talk more broadly about this in the context of the AI bill. But I'd say for children overall, yes, we need something that that gives us a framework as providers to design our products that is with respect to the age of our different users. So that's the framework that's emerged globally, and I think that's the same kind of idea that we want to see here in Canada.
Thank you. And finally, I have one more quick question for Microsoft related to national defense. We haven't spoken a lot about national defense in the context of artificial intelligence at this committee, largely because national defense is outside the scope of this regulation. But what's interesting is that we hear a lot about the possible harms that Canadians can face from artificial intelligence designed by national defense systems in countries such as Russia and China, which are being discussed right now at the Foreign Interference Commission that's taking place. What what is Microsoft doing with the government of the United States to counter some of the actions taken by China and Russia in respect to AI and destabilizing democracies like Canada?
Certainly. So we are in active conversations with governments across North America around how do we make sure that our elections are safe, how do we ensure that we stamp out disinformation. We also have strong connections with defense here, where we see that they're putting in place AI programs that have responsible safeguards and tools to ensure that there's proper human oversight in this new world of conflict.
Okay. Is there the possibility of overlap between the roles of national defense, personal security, the application of AI, and the threats we face? Does this need to be studied further?
I believe absolutely it does need to be studied further.
Thank you.
Merci, Monsieur Vice. Monsieur Turnbull.
Thank you very much, Mr. Vice. Mr. Turnbull.
Thanks to all the witnesses for being here today. I'm really finding the exchanges valuable, and your insights and expertise that you're lending to this conversation I think is making a big contribution to the conversation today. So thanks for being here, all of you. Look, I think your companies are all very large, very profitable, very successful, in part because of what my colleague Mr. Sobera said, which is that you're generating a lot of value for your customers. At the same time, I think all of you are trying to demonstrate leadership in responsible AI and the use of responsible AI, and I think that's great. I think as legislators, of course, we have a big role to play and have to make decisions based on what's in the public interest. And I think we're partners in that conversation. So I appreciate our ability to work together and your candor in terms of the comments you've made. I want to ask, earlier this week we heard from Yoshua Bengio, who sometimes is referred to as the godfather of AI. He was quite, I think, expressive of the exponential benefits and risks that are growing as AI evolves. And so this sort of highlighted, at least in terms of my perspective, the need for speed in terms of getting this legislation through Parliament. And notwithstanding that there may need to be some amendments and some changes, do all of you agree that we need, as the Canadian government, we need some speed and to make sure this legislation gets done? Can I just go through each of you with a quick answer? Ms. Foster?
To be honest, I don't know that the legislation changes much how we are going to be approaching responsible AI. So it will change the level of compliance and complexity that we have to comply with, but it will not it may actually in one way divert resources towards compliance and away from responsible AI development. But I don't that would not be a reason not to legislate. I don't think any of our companies are slowing down our efforts to ensure the responsible deployment of this technology and continue to rapidly innovate and invest to ensure that we're doing the right things. I think some of the existential risk is very theoretical, and I think we're very, very focused on some of the real kind of risks that need to be mitigated in how AI is deployed today. I think we continue to kind of invest in determining what the next iteration of AI requires from AI developers. Mm-hmm. And so how do we manage some of those emerging risks around hallucination, toxicity, as well as how do we develop appropriate red teaming and safety testing for these generative AI models. So I don't think it actually will change how we approach responsible AI. But I'm trying not to interrupt you,
but it wasn't a short answer. But I appreciate that I'm asking a tough question, perhaps, to answer in a short answer. We politicians do that a lot, I find. But I didn't do it intentionally. I'm just trying to get a sense whether you agree that speed is necessary. I take it from you, you're saying that you almost don't need government legislation because you're already responsible in AI development and usage. I mean, we could probably beg to differ that, and you've said already yourself that doesn't mean government shouldn't actually legislate. So maybe I'll move along the line here to Ms. Curran.
Yeah, I do think speed is necessary, and if for no other reason than to maintain public confidence in AI and in our products and services. I think it's important to get it right and not make sure you sort of step on the work that's being done by the Canadian AI ecosystem. But I think speed is a good idea. Passing something is a good idea.
Thank you. Ms. Craig?
And we agree that there's a need to move quickly with amendments, but also deliberately. My colleague did mention earlier the idea of the importance of consulting with other industry sectors, and that is one thing that we do think would be incredibly valuable because of the breadth of impact, especially to lower risk systems, and how that will impact Canadian businesses across sectors.
Thank you. Ms. Patell, online? I see your hand up.
I think we would say, go to the proverb, if you want to go fast, go alone. If you want to go far, go together. And we see this as a real global opportunity, and we want to go far together. So I think that this is one of those areas where we need to collaborate with international partners to get this right.
Okay, great. Thank you for your comments there. So I'm going to ask another sort of general question. How many of you have adopted the voluntary code of conduct on the responsible development and management of advanced generative AI systems? Ms. Foster, short answer.
Sorry, which code of conduct? Is this the
code of conduct that the government of Canada announced and produced in consultation?
We have aligned to the White House commitments and look to see those internationalized through an international consensus.
So not the Canadian Code of Conduct, but the American. Okay, got it. Ms. Curran?
Yeah, we asked to be included in that Canadian code. We were told it was for Canadian companies only, so we were one of the first to sign on to the White House commitments, and we are signed on to other voluntary codes that are similar.
Okay, thank you. Ms. Craig?
We're also focused on the effort to define a global standard, a global code of conduct through the G7.
Okay, and Ms. Patell? Is that the same for
Similarly,
you?
we're focused on international entities like the G7, and that's an area where we can work with Canada, which is also active in that the development of that code of conduct.
Okay, thank you. And all of you have made comments. I'm going to switch tracks here a little bit, but all of you have made comments on, I think, the definition of harm and defining material harm. But all of you have described slightly different ways that you perhaps determine that yourselves internally, right? So I think that's what I heard. I can repeat back some of the things that I jotted down, but it sounded like there was a slight variation in terms of how you assess that internally. And most of you have said that a lot of what you consider to be a high impact system depends upon the use case. So sort of two questions here. I mean, maybe I'll start with the use case question because I think it's the most, probably the difficult one. My feeling is that if we were to try and predict all of the various use cases, Ms. Curran, you had said that we should sort of identify the use cases that we're concerned about, and then I think you said identify the threshold of harm, if I'm not mistaken. I just find that, like, as regulators and legislators, it would be very difficult to determine all of the various use cases. I'm sure you can't predict use cases either. So what I'm struggling with is how is that an actual real approach for a government or legislators to actually take? Could you maybe respond to that?
Yeah, I think so. I think you can do both things at the same time. I think you can set a materiality threshold that's broad and potentially applicable to an infinite variety of use cases, and also outline specific use cases that you are concerned about. So including election disinformation, including provision of, healthcare services or employment services, but have that overriding threshold of materiality that applies to a broad range, an infinite range of potential use cases.
So it's sort of an inclusive set of use cases that would be ever expanding.
Exactly.
Would that not be through regulation potentially? Because that would be the natural way to probably update that.
Yeah, you could. I think our concern is that the minister's proposed amendments identify use cases or specific scenarios that we don't believe are high impact. So that's where we've identified concerns around things like content moderation and prioritization, and also the fact that there is no threshold for harm in the bill currently.
So, and you think that, do all of you agree that some threshold for harm needs to be added to the bill? Can I maybe, again, I'll start with you, Ms. Curran, because I was, you were responding directly to my previous question, but maybe I can just really quickly survey the panel before my time is up.
Yes, we agree with that. There should be a threshold for harm.
Okay, Ms. Foster?
I think that this is the incredibly challenging part of trying to horizontally regulate.
Tell me about it.
One technology with that has this incredible breadth of sectoral application, and the depth and breadth of AI is immense. And trying to kind of come up with something that factors in all of these use cases is so difficult. And the reason it's so difficult is also because how you manage harm or manage risk is going to be so specific to the data that you're working with, the population that you're engaging with in terms of who's going to be interacting with these systems, that trying to do this as a horizontal piece of legislation is a little bit of a fool's errand. Really trying to kind of look at how different sectors can who have the expertise in their sector is going to be a lot more specific and efficient from a regulatory approach. So these are the regulators that have the expertise in these complex sectors that already manage risk. And I think that there will be a need for maybe a backstop piece of legislation, and other countries have identified this. The UK has identified this as an approach that they are looking at taking, but they're waiting to legislate. They're doing the work by sector first, and seeing where the gaps are that need to be filled. I think I think what you're being asked to do as a committee and with this piece of legislation is extremely difficult, and it's going to be very, very difficult to actually make sure that we get at the risks that we want to target.
I feel the empathy building for our task. Ms. Craig?
So additional work needs to be done on the definition.
Microphone, please.
Additional work needs to be done on the definitions and perhaps taking a principles-based approach. One of the things that really surprised me when I was talking to an insurance underwriter and their use of AI was that they don't use AI for all their claims adjustment. They said, look, 10% of our claims are silly simple. So we're going to have AI do the silly simple ones. We'll get that work out of the way, and then we'll keep the people to do what people are uniquely qualified to do: creativity, ingenuity, critical thinking. And that was taken off the table. So now if I look at harms and categories of uses, now does that fall into a high impact use because you're using it for claims adjudication, right, but it's the silly simple ones, or not? And so, there is a need to really go back and look at those definitions and say, look at how these tools are actually implemented in the real world. And I don't think that's been done sufficiently across the broad communities, as was said.
Okay, Ms. Patell, very quickly, because I know my chair is going to cut me off for sure.
No problem. So I think for
generous with everybody.
To your question about should there be a threshold or some sort of test for harm, I think we would agree that there should be. And this is maybe just an issue of clarification, because elsewhere in the bill, there are references to significant or material harm. And maybe what we really need to do is just to have some consistency in the language. The final thing I'll say here is that I think these recommendations all actually speak to the ability to make some adjustments in this bill and land it in a really workable place, which is if you have use cases that are about the material harms you're concerned about, whether that's health impacts or economic outcomes, and then insert some factors in terms of what is a high impact system to give clarity there, establish a test for harm or a threshold for harm, and then, enable and empower sectoral regulators to do what they do best. And that's draw upon their, extensive expertise to apply that approach for their areas of regulation. I think that can provide a path to have the type of flexible policy framework that you're looking to build.
Thank you very much.
Merci beaucoup, Monsieur Généreux.
Thank you very much. Mr. Généreux, you have the floor. 5 minutes. Thank you, Mr. Chair. Thank you to all the witnesses. Mr. Bengio was here last Monday. Well, we heard him at a distance, but he said we need to hurry and adopt this law because within a decade or maybe even within 2 years, there will be robots out there as intelligent as humans. and they'll be making decisions. In the La Presse newspaper today, there was an article on the digital age. In 2019, with the pandemic, 1 million jobs or thereabouts were created in your 4 companies, plus Apple. And since then, especially in the last 2 years, some 125,000 of those jobs disappeared, and it's not over. Now, the jobs that were created, does it mean that employees today paid the price for all of the tools they developed back then that gave rise to the loss of their jobs now? Do you understand my question? I mean, AI has created tools, and now jobs have been eliminated. So is this the beginning of a drop in employees? I own an SME, and we have tools. I'm in communications business. And with websites, and you know, we can create websites within 5 minutes with ChatGPT, and we have to adapt to these changes. Now, might we be creating more jobs in the future or fewer jobs in the future, given all of the IT technologies and AI? That's my first question. My second question, Ms. Craig, you talked about R&D, Ms. Curran as well. Now, I wonder, in Canada, with this bill, and I'm referring to this bill, might we undermine R&D? I mean, if we have too tight a framework, I mean, the regulations that would then modify or regulate AI in Canada. I'll listen to your answers, one after the other, if you will.
I keep having to go first. I can speak to a little bit the impact on jobs. I think we're pretty conscious of the fact that new technology changes, the employment landscape. Not very many of us work in facilities that have, secretaries and receptionists anymore. There's a lot of functions of those roles that, for example, technology has kind of taken away the need for those things. I think we will definitely experience a transition in our economy, but I think some of it could be extremely beneficial. So as a country, when we think about AI adoption and maybe where we want to really sort of encourage strong AI adoption, we should look at sectors where we already have underemployment, labor shortages. So healthcare is a great example, but the construction industry would be another example where targeted sort of applications of AI can actually help alleviate labor shortages and ensure, for example, that, some of the administrative burden that doctors and nurses face can be alleviated through different AI applications of AI and ensure that they're able to focus more on patient care. So I think we expect to see change. I think in some cases, AI actually creates new economic opportunity and different types of employment. But I think change is a certainty.
Okay.
Yeah, I agree with that. So it will change the labor market. I'm actually really optimistic about this. 200 years ago, 72% of North American workers were farmers. Now it's less than 2%. 60% of the jobs that exist in North America in 2018 didn't exist in 1940. So I think we're going to create a whole new set of jobs, but what is going to be incumbent upon governments and policymakers is to work with companies to make sure we're training the labor force of the future and making sure Canadians are getting the skills they need to enter what's going to be a whole new workforce with a whole new set of jobs. And look, I agree with Nicole as well. In an era of labor shortages, AI is going to be, the best tool we have to solve some of those issues. Just on the issue of research and development too. Yeah, look, our global AI research is based in Montreal. Like Dr. Joelle Pineau, who I am hopeful can appear before this committee at some point, can talk to you about the amazing work she is doing out of Quebec to catalyze AI research globally. And I think the wrong regulatory framework, overreach, or over-regulation by the government is going to drive that kind of activity out of the country. And I would hate to see us lose that because we are world leaders when it comes to AI research.
Greg?
A brief answer.
Let's go just on the innovation and research.
Sure. So I do think because of the way that the bill very broadly affects even lower risk technology, it could impact research and innovation and could dampen innovation and ultimately result in reluctance among Canadian businesses, including small and medium-sized businesses, to adopt AI, to feel confident that they can meet regulatory requirements in using AI for innovation, and ultimately then impact the competitiveness of those businesses and of Canada.
Merci beaucoup.
Thank you very much. I'm going to have to put an end to this round. Ms. Lapointe, 5 minutes.
Mrs. Curran, the media reported on a recent decision by Meta to allow a manipulated video of the President of the United States to remain on your platform. And I note that Meta's oversight board stated that the loophole threatens elections worldwide and should be closed as soon as possible. So that's a pretty big and serious statement. And I think all Canadians want and expect Meta to adhere to ADA legislations once implemented. So can you tell the committee today what does your organization currently do to protect against altered video content, and what would be done differently when ADA is applied?
Yeah, thank you for that question. So we do have policies, clear policies against manipulated media, whether it's video or audio, if it's misleading, and we remove that kind of content. Now, look, sometimes, we set up the oversight board a number of years ago to give us guidance on some of our content policies. And that's exactly what they've done in this instance. They've said, look, you made the wrong decision in this case. And they've given us guidance on how to apply our policies going forward. And I think that's exactly what we're going to do. But we've got, kind of industry-leading tools that are going to help us detect and remove AI-generated content. Certainly for political ads, social ads, we're requiring advertisers now to disclose when they're using AI-generated content in those ads. And we just announced for organic content labeling requirements. So we are going to label any AI-generated content as AI-generated, so that users are aware when they're seeing images on our platform that they are generated by artificial intelligence. And we're working with other industry members to make sure we can extend that to video and audio when it's technically feasible. But that work is underway.
Thank you. My next question is for all the witnesses, and I'll ask for some brief responses. It's clear, governments, that we need to work with social media platforms. We've heard that very, very loudly today, to protect both individuals and critical infrastructure systems. And interoperability will be key to that. Will this legislation help define expectations for your organization? And I'll start with Ms. Foster.
Certainly. I think as we engage in discussions about potential regulatory frameworks and guardrails, it always informs sort of how we approach, where we think we need to focus in terms of responsible AI development and tooling for customers. We want to make sure that our customers are able to comply with laws as they emerge.
Okay. Thank you. Ms. Curran?
Yeah, so if the question is ADA going to help us set guardrails in Canada? Maybe. It sort of depends. It depends where things land. I think if some of the amendments that the ministers proposed that we're concerned about are included in the legislation, I think we need to think about how we respond to that. But look, overall, we think regulation is a good thing. We think guardrails are a good thing. By and large, ADA in its original form is a pretty good bill. So it's just a question of whether we can get the details right.
That's great.
So Innovation, Science, Economic Development Canada has created a working group called the Canadian Forum for Digital Infrastructure Resilience. I chair the AI and ML working group that's looking at critical infrastructure, brings together a variety of different companies to have these conversations. We're working through and wrestling with the language in ADA, definitions, and how that applies across critical infrastructure. We as companies support critical infrastructure providers, but we're not necessarily the providers ourselves. And so the call to invite others in the agricultural sector, the water sector, manufacturing sector, to understand how these tools and solutions intersect is going to be critically important as we move forward.
Thank you. And our online witness?
Yeah, I'll just say here, I think we're looking for more clarity. And so, in order to answer your question, we really need to see some clarity in both the legislation itself and in terms of how it would be applied.
Merci beaucoup, Madame Lapointe.
Thank you, Ms. Lapointe. Mr. Garon. Thank you, Mr. Chair. We're coming to the end of these testimonies, to the end of this panel, and I'm trying to assess what I've heard and your positions on regulation so I can constructively reflect on this. And I have to acknowledge I'm a bit confused. And I say collectively, do we need to regulate? Answer is yes. When we say, should we avoid this? Answer is yes. Then we get to the detail. We're told, well, C-27 is not the right thing. There's too much in there. The bill is trying to cover too much. So you're sort of telling us we would need all of those different legislations: Health Canada, the Electoral Act, Privacy Act, Criminal Act, publicity, child publicity. So that would require unending, legislative type of work, especially in a parliament like ours. And bottom line, we'd end up with no regulation. Now, if we were to have a bill where we could modify all of those laws at the same time, you'd say, well, we have the problem of C-27. So I do understand there's public relations, there's strategy in this, and maybe it's my bad habit to be so frank, but is this your way of telling us you don't want regulation? And take the time that's left.
We're arguing for no regulation. I think that where there is a desire for speed, and we support good regulatory frameworks. All of us do. I think where there's a need for speed, there is actually potentially opportunities for government to move more quickly with existing legislation.
Je vais vous poser une question précise.
Well, I'm going to ask you a precise question very quickly and right now. Do you think Health Canada has the expertise, because they already have trouble with drugs right now, but do you think Health Canada has the expertise to do it? The Commission on Elections that's around the corner has expertise for this?
To actually regulate and make decisions more quickly than it will take for this bill to pass and develop regulations and then develop the expertise to understand a Health Canada use case. I actually think that those regulators are in a position to understand where risks lie more quickly in those specific areas.
And if your companies, and Mr. Chairman, perhaps you could follow up, could your companies table in writing with our committee a list of all of the laws separately that would need to be modified? That might be constructive. Would you be able to do that? I would like to see that.
Need to be amended. They may actually, or you may, or the government may already have authorities that are technology neutral. So a lot of the things that, for example, the committee has discussed or that we hear discussed are things that are already actually potentially addressed in existing law. And if you apply the law in a technologically neutral way, you actually may already have the powers to address those issues.
But you could table this with the committee? I mean, we want to be constructive. Could you send us a list of all of the separate laws that would need to be modified? Thank you, Mr. Garon.
Et dans les deux langues officielles par la suite.
And in 2 official languages, of course.
Sachez que vous pouvez toujours soumettre.
And rest assured that you can submit, documents, your briefs, whatever you believe to be relevant. and you can send these to our clerk. Unfortunately, we're running out of time. I was, a bit lax with timekeeping this committee. Mr. Massé, the floor is yours.
Thank you, Mr. Chair. Appreciate this. In response to Bill C-18, Ms. Curran, Meta pulled the access to news articles and so forth and sharing. And one of the criticisms of that from many experts was that it was going to make children and youth more vulnerable to abuse. And your CEO, Mark Zuckerberg, at least apologized to Americans for what has taken place and when he was doing congressional hearings just a few days ago. Can you explain to us, like in terms of a trust factor, again, as I'm trying to get at here, what type of an analysis has continued from the point of that? Do you, I guess, disagree with the experts about that exploitation taking place through the products that you have? And is something, are we getting the same protections for our youth? I'm surprised that there hasn't been a general wider apology. I don't know what the difference between, other than citizenship, is those that have been succumbed to this, and it's caused significant problems, including connections to suicide and self-harm. So can you, at least to us in the committee, assure that there is an analysis continuing going on with regards to the response to C-18 and whether or not Canadian youth are further at risk or greater at risk because of the decision and spread of misinformation that affects them mentally?
Yeah, thank you for that question, Mr. Massey. I think these are two separate issues. So youth safety and youth exploitation online is a really key critical concern of ours. We just announced the further rollout of an initiative with the National Center on Missing and Exploited Children, which is going to ensure that intimate images, sexploitation, those images are more easily removed from platforms. So we're assigning an individual digital code to those images. Youth can do that themselves from their devices without sharing the image. And once that code is received by us and by NCMEC, the National Center on Missing and Exploited Children, we can fan out and make sure those images are not shared more broadly on our platforms and across the internet. So we are taking a number of steps to make sure that youth are protected on our platforms. It's an ongoing battle, I will have to say, and we're working with other members of industry to make sure youth are protected. That's very different from the issue of C-18 and online news content, which we have had to remove as a compliance strategy in response to the government's legislation. We didn't want to have to remove that news content. If we are carved out of that bill, we would be happy to put it back up. And I'm hopeful we can continue to work with the government on that front.
Well, I guess I'm almost out of time, but what I guess I'm really concerned is the response to C-18 is not the same across different countries, and the spread of misinformation related to the topics that I've noted are particularly troublesome. And can I, at least again, is there any analysis going on that C-18 and the response by Meta has put youth at greater risk or less risk with the spread of misinformation? And again, your CEO has at least apologized to Americans, not the Canadians, but to Americans on this issue. And is your response to C-18, is there ongoing analysis that it has further harm and spread of misinformation affecting the mental health of young people that are using your product?
Again, no other government has pursued legislation like C-18. We would be happy to work with the government to put news content back up if they're able to carve us out of that bill. The Canadian government is unique in pursuing that particular piece of legislation. That is separate and apart from our efforts to protect youth on our platforms, which are ongoing, and we've had a number of kind of recent announcements in that respect. We're going to continue that work very actively because it's a key critical priority for us. Again, it's quite separate from the issue of news online in Canada, which we have had to remove in response to the government's Online News Act.
Okay, thank you, Mr. Massey. We're almost out of time. Actually, we are out of time, but I'll just give one more minute to Mr. Perkins for a last question, and I hope he remembers this kind gesture when we get to clause by clause. Mr. Perkins.
I will remember all your kind gestures, and this is not the first one. Just a quick question, Mr. Wiegold, if I said. One earlier witness we had here I've met with subsequently and said when it comes to thinking in the future and artificial general intelligence as well, something that's missing in the bill is the ability of the government to regulate based on computing power. Should such a clause be added to the bill that gives the government the ability to adjust as time goes on with computing power?
There are different schools of thought around the computing power required for these models. And we've certainly seen in the European Union where they've put a metric out for that. There's exciting new developments in what are called small language models, SLMs, and a huge open source community that is building very, very powerful models. And so I would propose against looking at performance and CPU capacity and look at capabilities instead and talk about what do these models actually do and what do they provide. And again, it's important that we put in place the guardrails to look towards the future so that when we have these new tools that come out, we have these powerful regulatory environments that help us then protect Canadians against the harm that could arise.
Thank you very much. Thank you to all of the witnesses